The conflict check system showed 0 hits for Meridian Industries, but I'd seen that case file on Thornton Whitmore's desk 3 times this week. I'm Waylon Rosenberg, 42, private equity partner at our cross-border firm here in El Paso. 20 years of practice taught me to trust systems over instincts. But systems don't lie about conflict checks. People do. The Meridian deal represented 18 months of client development. Fortune 500 manufacturing company seeking acquisition targets in Mexico. My specialty. My contacts. My pipeline that started with a cold call to their general counsel last spring. I pulled up our case management system again, searched every variation of the client name. Meridian Industries. Meridian Manufacturing. Meridian Corp. Nothing. The system showed no active matters, no prior representations, no conflicts identified. But Thornton's office told a different story. Tuesday morning, I'd walk past his corner office. Meridian letterhead spread across his conference table. Wednesday afternoon, same. Today, I caught him sliding documents into his briefcase when I knocked. He'd looked up with that practiced smile partner's perfect over decades. Just reviewing some potential conflicts, he'd said. Nothing urgent. Thornton served as our general counsel. Conflict checks fell under his jurisdiction. If anyone could manipulate the system, he could. I logged into the billing database, searched for any Meridian entries. The query returned empty results. No time entries. No expense records. No client codes assigned. My phone buzzed. Email from Meridian's general counsel. Waylon, thanks for the excellent work on our preliminary due diligence review. Looking to discussing next steps with your team next week. I stared at the screen. What preliminary review? I hadn't performed any work for Meridian yet. Our engagement letter remained in draft form. I called our IT director. Natalia, I need access logs for the conflict check system. Last 30 days. Sure thing. Any particular reason? Routine audit. Send them to my personal email. The logs arrived within an hour. 47 pages of user activity. I scrolled through timestamps, searching for Meridian-related queries. There. 3 entries from Thornton's login, all dated after my initial client contact, all showing no conflicts found results. But something else caught my attention. The query parameters looked wrong. Instead of searching Meridian Industries, Thornton had searched Meridian Ind. The truncated search would miss exact matches. Deliberate or mistake? I ran a manual search using the full company name. The system immediately flagged a conflict. Our firm had represented Meridian's primary competitor in a trade secrets dispute 2 years ago. Standard conflict that would require client consent or withdrawal. My chest tightened. Thornton knew about this conflict. He'd worked on that trade secrets case. I printed the conflict report and walked to his office. Empty. His assistant said he'd left for a client meeting, wouldn't return until tomorrow. The Meridian files were gone from his conference table. I returned to my office and called Meridian's general counsel directly. This is Waylon Rosenberg. I wanted to confirm our meeting schedule for next week. Actually, we've decided to move with different counsel. Thornton Whitmore contacted us yesterday. Apparently there were some internal conflicts at your firm that prevented you from handling our matter. The line went dead. 20 years of practice. Hundreds of deals closed. Reputation built on integrity and results. And Thornton had stolen my client with a fabricated conflict story. They told me which clients would test my ethics. The warning came during my first week at the firm, 15 years ago. Fresh from big law in Dallas, eager to build cross-border expertise in El Paso. Thornton Whitmore, then a senior associate, had pulled me aside after the welcome lunch. Private equity work attracts interesting characters, he'd said. Some will push boundaries. Others will try to buy your soul. The trick is knowing which battles matter. I'd respected that advice. Thornton understood the delicate balance between aggressive advocacy and professional responsibility. We'd worked dozens of deals together. Built trust through late nights reviewing acquisition documents and navigating complex regulatory frameworks. When the partnership promoted him to general counsel 3 years ago, I'd supported his candidacy. Thornton knew our systems better than anyone. He'd modernized our conflict-checking procedures, implemented new case management protocols, and streamlined our client intake process. Now I understood why. The Meridian theft wasn't random opportunism. It was systematic manipulation of our firm's infrastructure. Thornton had positioned himself to intercept my best prospects while maintaining plausible deniability I needed before making accusations. The next morning, I arrived at the office before sunrise. Security cameras tracked movement after hours, but early arrivals looked routine. I accessed our billing system using my administrative privileges. Thornton's time entries showed unusual patterns. Multiple conflict research charges to our firm's overhead account. Each entry corresponded to dates when I'd logged new business inquiries. I cross-referenced his calendar with mine. Every time I'd scheduled an initial client meeting, Thornton had blocked corresponding time slots. His entries were vague: client development activities or strategic planning sessions. The pattern extended back 18 months. I pulled client files for deals I'd lost during that period. 7 major transactions. Combined value exceeding $200 million. All had involved preliminary discussions that ended abruptly, with clients citing conflicts or internal firm issues. My phone buzzed. Text from an unknown number. "Check your email, friend." A new message waited in my inbox. No sender identification. Subject line: "You're not the first." The email contained a single attachment: a spreadsheet listing client names, contact dates, and outcome summaries. 12 entries total. 5 showed my name as the original contact attorney. 7 listed other partners. All had been redirected to Thornton's practice group. The final column showed revenue figures. Thornton had generated over $4 million in fees from stolen clients. I printed the spreadsheet and locked it in my desk drawer. Someone inside the firm was documenting Thornton's activities. But who? And why help me now? The morning partnership meeting started at 9. I attended remotely, claiming a client emergency. Thornton presented his quarterly numbers with characteristic confidence. His practice group had exceeded revenue targets by 30%. Exceptional business development results, he announced. Our cross-border capabilities continue attracting sophisticated clients. The managing partner praised Thornton's strategic vision and client relationship management. Other partners nodded approvingly. Thornton's success elevated the entire firm's profile. After the meeting, I called our former IT director. Natalia Thornton had left 6 months ago for a position with a technology consulting firm. We'd maintained a professional relationship. "Waylon, good to hear from you. How's practice?" "Complicated. I need advice about digital forensics, hypothetically." "What kind of digital trail are we discussing?" "Case management logs, billing records, email metadata. Someone might be manipulating client intake procedures." Natalia paused. "That's serious. You'd need expert analysis to prove systematic manipulation, but the would be conclusive if properly documented." "Could someone with administrative access alter historical records?" "Absolutely. Especially if they understood the system architecture. Most firms don't maintain adequate audit controls for internal users." "What would you recommend?" "Preserve everything immediately. Screenshots, printed records, backup files. Then engage independent forensic specialists before confronting anyone." I spent the afternoon documenting screenshots of conflict check results, printed billing reports, calendar comparisons, email chains showing client communications. The pattern was undeniable. Thornton had weaponized his general counsel position to steal business from partners while maintaining the appearance of ethical compliance. But I needed more than circumstantial. At 5:30, I walked to Thornton's office. His assistant had left for the day. His door was closed, but I could hear him on a conference call. "The transition went smoothly," he was saying. "Waylon never suspected the conflict issue. Your matter is now exclusively within my practice group. I recognized the voice on speakerphone. Meridian's General Counsel. Excellent work, Thornton. This arrangement protects everyone's interests. When can we schedule the signing ceremony? Next Friday. I'll have final documents ready by Wednesday. I retreated to my office and called the anonymous tipster's number. It went straight to voicemail. No greeting message. This is Waylon. I received your information. We need to talk, tonight if possible. My phone rang 20 minutes later. Parking garage. Level 3. Northwest corner. 1 hour. The voice was female, familiar but distorted. I arrived early and waited near the stairwell. Footsteps echoed from the elevator bank. A figure approached wearing a dark coat and baseball cap. Natalia Whitmore. Our former conflicts coordinator. I've been documenting his activities for 2 years, she said without preamble. Started when I noticed irregularities in the conflict database. Thornton was modifying search parameters to hide actual conflicts while creating false conflicts for cases he wanted. Why didn't you report this earlier? I tried. Brought concerns to the managing partner. Thornton convinced him I was disgruntled about my performance review. They offered me a severance package to leave quietly. But you kept investigating. I maintained remote access to certain systems. Thornton never changed those credentials. I've been building a comprehensive case file. She handed me a flash drive. Everything's documented. Financial records, system logs, client communications, enough to prove systematic fraud. What do you want in return? Justice. And protection. Thornton threatened my career when I left, said he'd ensure I never worked in legal technology again. I pocketed the drive. I'll need time to review everything. You don't have time. Thornton's planning something bigger. He's been meeting with headhunters, preparing to leave the firm and take his stolen client base with him. The parking garage felt suddenly cold. When? Soon. Maybe weeks. He's already incorporated a new practice entity. Filed preliminary paperwork with the state bar. My 15-year partnership was about to be destroyed by someone I'd trusted completely. I spent the weekend reviewing Natalia's C. The documentation was devastating. Thornton had systematically manipulated our conflict checking system for 18 months, stealing 47 cases worth approximately $2.3 million in fees. Monday morning, I requested an emergency partners meeting. We have a serious problem, I announced to the 5-person partnership. Thornton has been falsifying conflict checks and stealing cases. I distributed printed summaries of the bousseau. The room went silent except for papers rustling. Managing partner Harrison Whitmore looked up first. These are serious allegations, Waylon. How did you obtain this information? A former employee provided documentation. Everything's verifiable through our own systems. Thornton leaned back in his chair, appearing calm. This is clearly fabricated. Natalia was terminated for cause. She's seeking revenge. The system logs don't lie, I replied. Your access credentials are embedded in every fraudulent entry. System logs can be manipulated by someone with administrative privileges, partner Rebecca Whitmore interrupted. We need an independent investigation. This can't be resolved internally. I had anticipated this response. I've already contacted the Client Trust Audit Authority. They're sending Government Trust Compliance Auditor Fiona Walsh to conduct a formal review. Thornton's composure cracked slightly. That's premature. We should handle this matter privately first. 18 months of systematic fraud isn't a private matter, I said. Our malpractice insurance carrier also needs notification. The meeting adjourned with thick enough to cut. 2 days later, Auditor Walsh arrived with a 3-person team. They established a command center in our conference room and began forensic analysis of our case management systems. Walsh was thorough and methodical. She interviewed each partner separately, reviewed financial records, and analyzed digital with specialized software. Mr. Rosenberg, she said during my interview, your documentation is comprehensive. How long have you suspected irregularities? 3 weeks. I noticed billing discrepancies on the Meridian Industries case. That led to broader investigation. This suggests systematic manipulation spanning 18 months. Were there no earlier warning signs? Thornton managed our conflict system. Partners trusted his expertise. He positioned himself as the sole authority on conflict resolution. Classic isolation strategy creates opportunity for undetected fraud. The investigation revealed additional violations. Thornton had also been billing personal expenses to client accounts and manipulating time entries to inflate his billable hours. Total damages exceeded $3.1 million. On Thursday, Walsh presented her preliminary findings to the partnership. The supports allegations of systematic fraud, client trust account violations, and professional misconduct. I'm recommending immediate suspension of Mr. Thornton's access to all firm systems and accounts. Thornton finally broke. This is a witch hunt. Whalen orchestrated this entire situation because he was jealous of my client development's success. The digital contradicts that narrative, Walsh replied calmly. System logs show deliberate manipulation of conflict databases to redirect cases from other attorneys to your practice. I was protecting the firm's interests. Some of those attorneys weren't qualified to handle complex matters. That decision isn't yours to make unilaterally. You violated professional ethics rules and potentially criminal statutes. The partnership voted unanimously to terminate Thornton immediately. Security escorted him from the building that afternoon. Walsh's final report documented 17 specific ethics violations and recommended criminal referral to the district attorney's office. The state bar initiated formal disciplinary proceedings within 2 weeks. Thornton's license was suspended pending investigation. Affected clients filed a class action lawsuit against the firm. Our malpractice insurance covered most damages, but the partnership faced significant financial strain. I spent months working with Walsh's team to implement new oversight procedures. We installed dual approval requirements for conflict checks and established quarterly audits of case assignments. Natalia agreed to return as our compliance coordinator. Her experience with Thornton's methods made her invaluable for preventing future fraud. Trust but verify, she said during her first day back. No single person should control critical systems without oversight. The district attorney filed criminal charges against Thornton in November. Wire fraud, money laundering, and professional misconduct. He pled guilty to avoid trial and received 18 months in federal prison. The Bar Association imposed permanent disbarment after his criminal conviction. Our firm survived, but barely. 2 partners left to join other practices. Client trust took years to rebuild. I learned that professional relationships require constant vigilance. Expertise and authority can mask systematic deception. The silence in Thornton's empty office reminded me daily that betrayal often comes from those we trust most completely. 18 months later, I stood in my new office overlooking the Rio Grande. The morning light reflected off the water, creating patterns that shifted with each passing moment. I operate a litigation support firm focusing on ethics audits. Former partners and solo practitioners hire me to review their compliance systems and identify potential vulnerabilities. The work feels purposeful. Every conflict check I verify, every billing record I examine, prevents another attorney from experiencing what I endured at the partnership. Natalia joined my firm as Chief Compliance Officer. Her understanding of case management fraud makes her irreplaceable for detecting sophisticated schemes. Another law firm wants our services, she announced, entering my office with a contract. They're concerned about their trust account procedures. What's their situation? Missing client funds. Small amounts over several months. They suspect internal theft but can't identify the source. I reviewed their initial documentation. The pattern looked familiar. Systematic withdrawals disguised as legitimate expenses. Someone with administrative access was stealing incrementally. Schedule a site visit for next week. We'll need full access to their accounting systems and personnel files. Already arranged. They're desperate for answers. My phone buzzed with a text from Walsh. The Government Trust Compliance Authority had referred 3 more cases requiring independent investigation. Word was spreading about our specialized services. The legal community in El Paso remained small. Attorneys talked. Referrals came from unexpected sources, including former colleagues who had witnessed our firm's ordeal. "Any word from the old partnership?" Natalia asked. "They're rebuilding slowly. New management, stricter oversight." The remaining partners learned expensive lessons about trust and verification. Thornton served 14 months in federal prison. His early release came with supervised probation and permanent prohibition from practicing law anywhere in the United States. I never saw him again after his sentencing hearing. Some betrayals create permanent distance that time cannot bridge. The class action lawsuit against our former firm settled for $2.7 million. Insurance covered most damages, but the partnership dissolved 6 months later. The remaining attorneys formed smaller practices or joined established firms. My new practice generated steady income from ethics consulting and compliance auditing. Law firms across Texas and New Mexico sought our services after learning about our experience with internal fraud. "The afternoon appointment canceled," Natalia reported. "That gives us time to finish the quarterly report for the state bar." "Good. I want to include recommendations about dual approval systems for conflict databases." "Already drafted. The technology exists to prevent what Thornton did. Firms just need proper implementation." Evening approached as I completed my final case review. The office grew quiet, except for the distant sound of traffic crossing the international bridge. I locked the filing cabinets containing our clients' confidential materials. Trust remained fragile, requiring constant protection and verification. The drive home took me past the building where our old partnership once operated. New tenants occupied the space now, a medical practice specializing in sports injuries. Life moved. Betrayal became experience. Experience became wisdom. Wisdom became service to others facing similar challenges. My phone remained silent during dinner. No emergency calls about missing funds or suspicious billing. No midnight discoveries of altered documents. The quiet felt different now. Not the silence of hidden deception, but the peace of transparent operations and verified trust. It was finally over, and the silence felt earned.